Hello, I'm attorney Thomas Burton. Welcome back to our popular question and answer series, where I answer real viewer questions from across the state of Wisconsin every month here on our YouTube channel. Today's question has to do with probate and is the following. My mother passed away and named my brother as representative. What happens if I don't consent to him? I have no reason to believe that he will treat me fairly. In fact, he has threatened me physically and won't let me in her house. Yet he and my sisters have ransacked her house. Excellent question. It sounds to me like your brother sent you what's called a waiver and consent form, and this would be used with informal probate to allow the will to be admitted to probate and to consent to his appointment as personal representative under an informal administration without a court hearing. So if he was named as the personal representative in the will, it's likely he and the attorney he hired to help with the estate would send you what's called a waiver and consent. And you say here your mother named him as the personal representative. So if he's named in the will, he would have a strong the court would be inclined to name him as personal representative unless there's evidence to the contrary. So if you do not sign the waiver and consent, then your brother cannot be appointed as personal representative without a court hearing. If you feel your brother will not do a good job as personal representative and carry out his fiduciary duties under both state law, statute, and the will, then you should not sign the waiver and consent, and I recommend you seek your own legal counsel before proceeding. Because if you sign the waiver and consent, you're consenting to his appointment as personal representative. So if you don't want to consent to him being appointed as personal representative, I would not sign it. And then your brother's option would be he would have to petition the court for a hearing to get appointed as personal representative. And that's where you and your attorney could present your arguments as to why he should not be appointed as personal representative. You also might want to think about who you would want appointed if you want to petition to be the personal representative, or perhaps you want to petition for a third party, a neutral third party like a trust company to be appointed as personal representative to administer the estate according to the will. So I would discuss that in private with your attorney, your strategy for that hearing, and what your arguments will be to the court as to why your brother should not be appointed and the other person appointed instead. But there's nothing requiring you to sign the waiver and consent, and if you don't want him to be appointed, then I would not sign that waiver and consent and seek independent legal representation as soon as possible. So thank you for asking, as this is a good question that illustrates what that waiver and consent does in the probate court process. If you are watching and this situation is helpful to you, please consider giving this video a like so that others can see and benefit from this information as well, because I create these videos to help others who are encountering similar situations and can later watch this video and benefit from the information contained. Thanks for watching, and we'll see you next time.